Hello and welcome to another episode of It's the Bottom Line That Matters podcast, where we are dedicated to your success. One of the things many business owners, and it doesn't matter if you're a startup, a small business, an established business, even a big business, a lot of businesses fail to realize what copyright law actually means. Very often you hear people create artwork and it's used by others without their permission. Or maybe you go to Google, you do a search for a particular image and you grab it and then you use it in your particular situation. We're going to be having a really interesting conversation today on why you should be aware of what may actually be happening if you do anything along those lines, and other issues that maybe you're not thinking about in terms of that idea. And we have a really incredible guest with us today who's going to help us understand what this all means to us as individuals and business owners in any way that we use intellectual property. And we'll also define that term too, so that you're clear on what that means. But before I bring our guest in, let me tell you a little bit about her. So Randi Karpinia is the CEO of Sagacity Legal, a firm that transforms entrepreneurs' ideas and inventions into intellectual property assets that can lead to huge profits. With over 20 years of legal experience, Ms. Karpinia is a recognized expert in all aspects of business legal operations with a focus on intellectual property rights and management. And Sagacity Legal, she guides her clients through the legal risks they'll face now and in the future, so they can focus their time and efforts on the value, expertise, and experience they bring to their business. Ms. Karpinia's expertise is well recognized industry-wide, including recently being honored as a 2021 Small Business Person of the Year finalist by the Chamber of Commerce of the Palm Beaches and included in the WIPF 2021 Powerful Women in IP list. Ms. Karpinia is admitted to practice law in Florida and before the USPTO, which is the U.S. Patent and Trade Office, and is a Florida Bar board certified intellectual property lawyer. Randi, welcome to the show. And I apologize again, by the way, if I butchered anything.
Thank you. And just for the record, it's Sagacity Legal.
Thank you. And again, I apologize. I'm looking at it and I knew it. So Randi, thank you for being here. And let me start with the biggest question. What is intellectual property? So that way we can kind of start with a basic understanding in terms of what we need to understand.
Yeah, that's a great question. And a lot of people may have heard it or maybe never heard of it. And most people think of it as something, oh, that's what big corporations worry about, not me, the solopreneur or the small business owner. But intellectual property is an all intangible assets that you create. So it could be an invention. It could be this video that you're recording, this podcast. It could be a brand, a logo. So anything that you create, that a person creates or a group of people create, becomes an intangible asset versus the tangible assets like our computers and phones.
Thank you. And so very often we see little marks following some information. Sometimes we see the R in the circle, we see a TM, we see an SM, we see a C in a circle. All of those are different kinds of protections that are given to the intellectual property holder. But can you tell us on a high level what the difference is between those different kinds of protection marks?
Yeah, and I call those the symbols. They're not really protections. They're really more like notices. And so I'll talk about what they mean, and there are different ones. So let's start with trademarks. And I know you introduced talking about copyrights, but let's talk about trademarks first. When you see an R in a circle on a name, a logo, anything like that, a phrase, that means that owner, that brand owner, has a registered trademark in at least one country. Could be the US, could be another country, could be multiple countries, but the R is the registered trademark only used once that trademark has been granted by a government office. Now, what's tricky is you mentioned TM. We see TM quite often. We see SM quite often. Those are actually what I call no trespassing signs. Anyone who believes that they own a name, a phrase, a logo can mark that even before they register it with the TM for goods, SM for services. And it's just telling everyone, stay away. I believe this is mine. So when you see that they're not registered, but they're claiming ownership, then you probably see copyright notices a lot. Copyright is an interesting law in that ownership of a copyright is upon creation. You actually don't have to register it. You own it. So I always tell everybody, if you create any kind of content, even your website, your podcast, I'll keep picking on you with your podcast, put a copyright notice, another no trespassing sign. If the material is something that is really important and you think you might have to enforce, you do want to register it, but the notice doesn't change. There's not like trademarks, it still just says copyright. And then for my inventors, they can say at the time that a patent is applied for, but not yet granted, patent pending. So you may see that sometime. And then you'll see patented, usually with a number, when their invention is granted a patent.
Okay.
Thank you.
Oh, Randy, yeah, Randy, I've got a question for you. Thinking for small business owners who maybe this is the first time they're stopping to think about different types of registrations or anything. My background is in music. I used to teach music, and so I became familiar with copyright law. And because you have to when you're a band director, somebody says, I lost my music, you legally cannot run over to the copy machine at school and make a copy of that piece of music and hand it to the kid. So there are legal issues there. But what I'm thinking is for the business owner who is either creating their website, or they're putting out flyers, or maybe they've created some kind of an online course to teach their material to someone. What would be, I just threw out a bunch of examples there, but what would be some of those little tiny things that a small business owner might overlook that could cause some legal issues if somebody begins to use their material and they haven't taken the time to register anything?
Yeah, it's very difficult for small business owners because, especially startups, they're looking at budget and what do I care about the most that I'm going to put the funding into. That's where the no trespassing signs we were talking about are a good starting point. But what I always say is you need to look at budget versus risk versus value. And those differentiators, people that follow me will see I use the term protect your uniqueness. Those differentiators that will harm you if they become commonplace. If somebody else or multiple people start doing the same methodology or services or offerings that you are, and you haven't protected it, you haven't noticed it, you haven't put terms and conditions on your website, because that has come up a couple of times as an example, that say that you own it, then the cost and the time to defend can become overwhelming. It can become totally overwhelming. The legal cost to defend, or the harm to your own competitiveness. So knowing from the beginning, really educating, and Daniel, as you know, I educate almost daily on social media for just this reason, is that I'm hoping that small businesses, people will something will catch their eye. But knowing what is your uniqueness what's going to give you the competitive advantage, and then identifying how to protect it.
That's great. And you mentioned a moment ago how simple it can be, especially to mark something with a copyright. I'm thinking of a case. I ran across a scenario where a gentleman had created a unique kind of fitness program, and he was beta testing it. He invited like 6 of his closest friends, and one of his friends stole all of his material and started marketing it and started using it. And it could have been as simple as just putting C in the circle with his name and date at the bottom of every page, right?
Yes, I'll add another fairly easy thing to do when you're beta testing anything, when you mark it confidential as well, confidential proprietary, and then you make those beta testers sign an NDA, a non-disclosure agreement, or a confidentiality agreement, so that you have made it very clear that this is yours. So in that case, now you have a breach of contract. You don't even have to have the copyright registered and go down that path, which copyright litigation can become very expensive. But breach of contract, that's not so expensive. It's expensive, but not as much so.
Yeah, and unfortunately, he thought he had invited 6 close friends, so he didn't think he needed.
You just never know.
Yeah.
I had a client several years ago who taught equestrians how to massage their horses. Highly effective way that she did it. And she had a student who took a 2-week course and then ripped off her materials and went and sold sold training to other equestrians for more than she was. And she didn't have the money to
Yeah.
pursue
I think
legal
there are so many, I mean, just the fact that both of you know these experiences, business owners, creators need to realize this is sadly a fact of life. And in both cases, registering and then sending demand letters and at least recouping the costs that are lost are helpful. But you know, it's a problem. I think with the digital world, it's become even more of a problem, because it used to be like in your case, Patricia, that originator would have had a in-person presentation, maybe not even provided the material.
Yeah.
The person couldn't have so readily just literally duplicated it and used it.
Yeah.
So let me ask a really important question here. If people are using our do not trespass protected intellectual property and we don't find out about it, how long do we have to go after those violators, A? And B, does the fact that we don't pursue prosecution, if you will, on some cases waive our ability to pursue prosecution in other cases?
So that's a really complicated question, but I'm going to simplify it. First of all, I believe, and again, I'm going to focus on U.S. law. I didn't mention that, but IP law is similar but varies from country to country. Just so I'll caveat in case somebody's listening to this in UK, the law may be slightly different. But in most cases, the clock for you to go after someone is when you know about it. So if you don't have knowledge or should have had knowledge, then the clock doesn't start ticking. In most cases, I think it's 3 years, like for copyrights, like 3 years from when you had knowledge. And then whether you go, so I just went through this with a trademark client. Where we actually had to go after multiple people who were using the trademark name around the country. And the decision of who to talk to, I'll be gentle, to talk to, were those that were actively harming her business. So it started with one major harm, and then the noticing, her identifying some others. But there were some smaller businesses that were really not overlapping or harming, and we again, budget versus risk versus value, that client only had a certain budget to work within. So it doesn't, to answer your question, if you, I don't want to say pick and choose, but if you only go after those that are really harming you, that's okay.
Okay, so I've got a follow-up question then based on that. So it is so easy. We were talking about being in a digital world a moment ago. It is so easy to hop on Google to look for an image that you want to use in your marketing or something and just grab one. But based on what you were just saying, I know that small business owners need to be cautious about using somebody else's protected material. So what could a business owner be facing if they are trying to play by the rules? But I get confused about this. How do you know if an image is copyrighted when you find it online?
Okay, so here's the way it works. Remember I said that copyright law, that copyright ownership begins at creation, whether it's registered or not. So let me get into my lecture mode. What I always tell people, because so many of us are producing social media content, website content, I have a YouTube channel, video content, you with your podcast. I'm going to kind of give you my 3 lines of defenses, and then I'll answer the question about what if you don't use them. So the first line of defense is always use your own material. I always say a B- creation is better than borrowing an A+ creator's work that could get you in trouble. So that's the first thing, as much as possible. I have a high school daughter who happens to be a fabulous artist. She's done a ton of brand photos for me that I can then use. I know they're ours, right? So I know she's not going to sue her mom. The second is getting permission, and this starts to go towards what your question is, Daniel. So the biggest, I think, culprit are these free image sites. Free images, use them. And everybody goes to these sites and uses them without blinking because it says they're free. But what they don't read are the terms and conditions of that website to know what permission they're getting. And that's the biggest issue. You have to have active permission from the originator. And those free image sharing sites, or grabbing a meme that somebody posted on social and reusing it without permission, you're opening yourself up to a major legal headache. And I'll talk about that in a second. And the third is, my third line of defense, that people always like their eyes pop when I say that, is doesn't matter if it's for business or for personal. If you have images or other content that you don't know where it came from, maybe you grabbed it from a friend who had posted something, delete it. Go through your feed and delete it. I have had clients who posted something on Facebook, true story, 3 years earlier. The photographer, it was just a very innocent thing. The photographer came after them, a law firm did. And then what happens? If the originator identifies that you've used something of theirs without permission, typically there's a law firm involved, you'll get what's called a cease and desist letter. And a lot of people see these and they're like, they throw it away. Like they don't realize this is real. You don't throw it away. You know, I've had people come to me again, well, this is like the 5th one and they're sounding really nasty. Do I need to do anything about this? Like, oh my goodness. But to settle and not, okay, so your choices are negotiate a settlement with take down the infringing material, negotiate a settlement, which always runs in the thousands, If we're lucky, we keep it under 10. Or you could end up in court. And litigation, just the attorney's fees, and I'm not a litigator, so I can say this, can run into hundreds of thousands of dollars. So it's a real issue. I typically have at least one act. I have one right now that just came to me last week. I typically at any given time have at least one active case where somebody has received a cease and desist, has done something innocently usually.
Wow. Those are some pretty stiff consequences there. So and now I'm rethinking again, also from my band director days, using copyrighted material in the classroom, and then also for the small business owner. So okay, so here's another question then that I hear come up. It was common when I was an educator, and I still hear it sometimes with small business owners. Is there such a thing as fair use, or it's not quite the right word, but under copyright law, I don't quite have the right term. But
no, fair use is fine. We can talk.
Okay.
I think that's something people understand. So as an educator, if you're in a nonprofit or public education system, then the rules are a little bit differently, and you can teach it, right? You can, a band can perform at their holiday concert a piece that's copyrighted, right? And we know about that. Normally, actually, a scenario, you'll still get permission. But if you're, say a person is a coach and they say, well, I'm educating, right? No, you're making money. There's no fair use. So people really don't get that. I've heard that a lot, where people think, well, because I'm teaching or because of some other thing they're thinking, they can use it, or, oh, derivative. Many people think if they take the work and change it, then they can use it. And the answer is no, not really. So, and I did want to mention, because you've talked about music a couple of times, YouTube and podcasts and videos in general, you can't just grab your favorite song and use it. You have to, just like everything else we've talked about, and people forget that background music, or maybe you just happen to have your some music playing in the background and you're recording a video and don't even remember a song, you could get in trouble.
Yep, very true. Somebody deserves royalties for that. They want their 2 cents, which is usually about what a royalty is for each play of a song, but it adds up over time.
So let me ask you a different question, because one of the things when you do get licensed material is there's something called a simple license, an extended license, and an editorial license. How do you know which one you may need to actually work with in order to not get in a problem when you're thinking that you're buying a licensed piece, but it may not be the right use for that piece?
That is such a great question, and it depends. And you really need to learn how to read the terms, read the licenses. There's another that's sometimes there's personal versus commercial. There's single use versus multiple use. I know I just went through it. That was something I was purchasing a few months ago. And I said, oh, wait a second. I need not only the commercial, but the multi-use, because multiple people are going to see this. It was something I was creating. So you have to read. For example, I had a client not too long ago who came to me to trademark their logo. And I always ask, where did it come from? Did somebody hand draw it, whatever. And their brand person said, I got it from this site, and no problem, I have a commercial license. When I read the terms of that license, it literally had a bullet item that said you cannot use it for trademarks. So it's not only which license, but it's how you're going to use it that makes the difference.
And one other thing just to note also is the font that is in use. If it's licensed for commercial use, if it's a purchased font, things that come with Microsoft Windows and Apple as a default, correct me if I'm wrong, Randy, I believe that's okay to use. But if there's other fonts that may be problematic, if it's not a default font that everybody already has access to, am I correct?
I think so. I won't say I'm an expert on fonts. Typically we all just use what we're licensed to use. But I do know there's distinct fonts out there, and I consider a font very much like an image. Again, you need to read the terms, and ideally, we can't create fonts, but don't use something just because it looks a little nicer, if you're not sure. So, and I did want to mention, by the way, it's not all gloom and doom. Most websites or most companies that do offer these different kind of content have some kind of contact information. And I've helped clients in the past actually go out and ask for permission. And you can do that.
Yeah, very easy to do. And even with sound clips too, if you want background music and video, it's real easy to reach out and ask for permission. Sometimes I know that, especially with smaller artists, they will even give you a one-off contract and say, yeah, sure, for you, let's charge this amount. So sometimes that can be negotiated. Yeah,
I was just talking to someone the other day, and because I had kind of fussed at him about be careful of your background music. So he went and found, I don't know, some local musician and got his own work done. He has his own music now.
May as well. Why not? What did you say? One of the 3 lines of defense, right? Do it yourself.
Yeah.
Yeah, nice. So I think it would be worthwhile, because I was just trying to rehearse what were those 3 lines of defense again. So it was create your own and ask for permission, right? There's 1 and 2. What was the 3rd again?
And if you don't know where it came from, or don't know if you have permission, delete it.
Okay. All right. Yeah, I think that's worth saying again. Yes.
I always say, just, if you drink wine, get a glass of wine, sit and scroll through your feed, even your personal Facebook feed, Instagram, whatever it is you use, and just get rid of it. Check your website. Every time I'm talking to someone, I have this bad habit of looking at their website and going, do you want all those images?
So here's a different question as it relates to what's in the background. So if you're outside as opposed to indoors, we know that there's a little bit more of an issue. But if you're outside and there's people in pictures, so you may need a model license, you may not need a model license. Certainly indoors, we know you do need a model license for anyone that's in a photo that you're using. But if it's outdoors and there's music playing in the background, and I want to ask this very specific question, because this is actually something that happened where I was notified by Facebook that a video that we posted, I think it was last summer, was deemed to be violating copyright for music that was playing in the background. It was the Isley Brothers who were having their song being played. However, what was not taken into account was the Isley Brothers were actually there for a street renaming in my town at the time that we were posting the video, and it was free and clear to be able to use, simply because it was part of the street renaming. They knew we were broadcasting it. Many of the media outlets were broadcasting it as well, or certainly the B-roll clips that were going on. But would you get involved in a situation like that? I mean, right now, Facebook took it down and there's no means for us to even challenge it, because if you tried clicking through a link, it doesn't go anywhere. And Facebook is one of those companies, support may or may not be the greatest to reach at times. Nothing against them. I know many of the support folks are very good at reaching out, but every now and then, the automated system may not be as good as the one-to-one. So as we look at something along those lines, is there a difference in that regard? And I know we're talking attorney-client, something that may be binding, and this is not in any manner, shape, or form giving legal advice.
Thank you. And we probably should have said that at the beginning. In fact, let's put that into the show notes. Disclaimer, this is information only. Nothing is binding in anything that we talk about today. So ideally, you would have actually gotten a release prior to the event. The fact that you didn't have it, you had no proof to submit to Facebook to say, I have permission. You said, I believe I have permission, but in reality, you have nothing in writing, then Facebook's going to take it down. And you really don't have, as you said, I won't say anything bad, but in general, because the social media company is just so big, it's very difficult to undo when things like that happen. I will say, though, I've been on the other end of it where clients have submitted to social requests for takedowns, and that also is a very burdensome process. So they do, it's not like as soon as you submit, it's gone. So some amount of affirmation was done to make Facebook believe that you were violating. Just because something is in the background in a public place, it's not, that wasn't the purpose, theoretically, of the music being played. You really need to have, and the same goes for, I'll just add to it, ideally people, right? Try to get backs of people, not faces of people, and brands. I've had to help a videographer where just by chance, one of his videos, somebody was wearing a branded jacket, and the brand owner came after him to take down the video. So it's really, it's so easy today. We're going back in a circle. The digital world is so easy. We talked about how we're all in different states and we're sitting on this podcast, but it's still infringement. And there's still very strict laws about what you can and cannot do.
Wow. And Randy, I know that you put out a lot of information on this subject. You've got a YouTube channel. I've watched some of your videos. You've got other places where you post information like this. What are some places that you have that people can learn more from what you share?
Thanks, and I do. I really try to provide at least that first level education so people can start being aware, like this podcast. My YouTube channel is Attorney Randi Karpinia. Really, really easy. And I'm posting videos about every other week. I think there's 40 or so. There's some real quick shorts that you can watch in less than a minute just to get some answers. And then there's some really, I think, some good content, even though I don't say I'm a video star. And yes, I create all my content. And then just to try to be where small businesses and entrepreneurs and creators are, I post regularly on LinkedIn. I have a LinkedIn newsletter. Once a week, a newsletter goes out so people can subscribe and get my content once a week. And I also post on Facebook. So I use Facebook more for business. So they can find me any of those three places, or my website, sagacitylegal.com. For those that do like to read, I have a blog.
Wonderful.
Thank you. And so as we wrap up our conversation, you're definitely going to want to be checking Randi out. You're going to want to be paying more attention and review those three pieces or levels of protection: to do it yourself, make sure you've got the right permissions, and if you don't know, take it down. Really pay attention to what it is that you're doing. Pay attention to what else you can be doing to ensure that your creation is going to be protected too. And remember those little do not trespass protections that we mentioned before you actually file. you can certainly start using some of those right now to protect your work before you go ahead and reach out to the US Patent and Trade Office if you're here in the United States, or the appropriate office where appropriate, and the Copyright Office is again something different under the Copyright Act. But there's a lot of pieces that you're really going to want to be paying attention to. And it is really important to protect your interests today, tomorrow, and in 3 years from now, for anything that is out there at the moment, and even longer than that. If you're really paying attention to what you're doing, you're going to be covered a lot more than if you're just going on Google Images and pulling an image. And we're not meaning Google, just Google. Any of the search engines is the same thing. Google is just synonymous apparently these days with doing searches. But if you think about what it is that you're doing, you're going to be a lot more protected. So Randi, on behalf of Daniel, Patricia, and myself, we want to thank you again for being our guest today. And everyone definitely reach out to Randi.
Good ways to get a hold of you, Randi. You mentioned your website, sagacitylegal.com. And
Yeah,
people can
so
find
I make it really easy. If someone wants to get on my calendar, they just need to go to meetwithrandi.com and they can schedule a chat and, see, I can give them some, tips, and we can talk about what they might need.
that is so easy. Wonderful.
Great, thank you. And on that note, this has been another episode of It's the Bottom Line That Matters podcast. And until next time, here's to your success.